Getting out of jury selection shouldn't be the goal. Jury selection, when it's done the right way and the experience of a trial is done the right way, can be a very rewarding one. What's the process of jury selection like for a juror? Because I've been on both sides. You get called down to the courthouse, and there's a massive group of people, all there for the same reason, jury selection, all with a few things on their mind. Am I going to get picked, and how do I get out of it? After that, you're filtered into a smaller group and sent to a courtroom typically, where a judge will ask you some preliminary questions. The focus of these questions is designed to screen whether or not you are an appropriate candidate to at least be considered as a juror for a particular case. Thereafter, what you may expect is that you will get called and impaneled into a jury box and then asked more specific questions. It will start out with a questionnaire that you will fill out for the lawyers to review, and then the judge and lawyers will both have a chance to ask you more specific questions. In a criminal case, in a misdemeanor, you need at least 6 jurors and a few alternates. In a felony case, where the crime is punishable by at least 1 year in jail, and it could be up to life in prison, you need at least 12 jurors and 2 alternates, but generally you will tend to have more alternates depending on the nature and the severity of the case. Now, what's the difference between a primary juror and an alternate juror? The primary juror will sit and hear all the evidence and then have a chance to deliberate at the end of the case. And we'll talk about what deliberation means. An alternate juror is just that, they're an alternate. If one of the primary jurors is unable to fulfill their duties as a juror, that alternate will be seated in their place and become a primary juror. Juries that are picked, they're picked because both sides either have agreed that they can be fair and impartial, or one of those sides, or both of those sides, have run out of challenges. What are challenges? In New York, there's a thing called peremptory challenges. Peremptory challenges afford lawyers an opportunity to excuse a juror without providing a reason, as long as it's determined that the reason is not a race-based reason, a race-neutral reason, as the courts have said. Now, depending on the type of case, you have a certain specific number of challenges. Now, you as a juror may not know the amount of challenges that the lawyers have, but the judge and lawyers have clarified what number of challenges they have before the trial starts, and they will go through that process. But once a lawyer runs out of challenges, typically the juror that's sitting next will be the one that's going to sit on the actual jury. They'll get picked. Now, if there's no peremptory challenges left, a lawyer does have an opportunity to excuse a juror if they can establish that that juror is unfit to sit on this case. And that's called a for-cause challenge. A for-cause challenge is different than a peremptory challenge in that it has to be for a specific reason that clearly demonstrates that that juror is not qualified to sit on a particular case. It may be that they have a strong feeling one way or another for or against a particular party in the case. It may be that they have something in their personal life that will prevent them from being fair to both sides. Or they just might have a scheduling conflict, the typical resort for most jurors to get out of jury selection. Now, once a jury is picked, a juror often wonders, well, what's my role? What am I supposed to do? Well, typically, it's just listen and keep an open mind. Some judges will permit jurors to take notes and use those notes to aid them in their memory while they're deliberating. Other judges will say, I don't want you to take notes because it may distract you from focusing on important parts in your role as being a juror. Now, what makes a juror a good juror? Well, someone who's a good listener, someone who is able to look at someone's body language and form informed conclusions. Jurors are asked to evaluate a witness's credibility to decide whether or not that witness is telling the truth. And they're asked to use their life tools and their common sense in reaching that very difficult decision. I mean, think about it as a juror. You're being asked to meet a complete stranger, learn a little bit about that person, and then hone in on what they say about a particular event, to decide whether or not you think what they're saying is truthful. Now, jurors can reach different conclusions about different witnesses. They could conclude that that witness is both honest and accurate about what they're reciting. They also may say that the person may be trying to tell the truth, but because of a variety of reasons, they may not be able to relate an accurate version of what happened. Also, jurors could reach the conclusion that a witness is outright lying. Now, in a criminal case, you need a unanimous verdict. That means all 12 sitting jurors have to agree on a particular result. If they can't all agree, and the judge discerns that the discord among the jurors is such that they're never going to reach a unanimous verdict, then that judge will ultimately be forced to declare a mistrial. Now, in a civil case in New York, there are typically 6 sitting jurors. As opposed to a criminal case, which requires a unanimous result, a civil jury only has to conclude 5 out of 6 jurors reaching the same conclusion in order to deliver a verdict. Now, sometimes there's an instance where a primary juror has an inability to fulfill their service. And sometimes that happens during the pendency of the case while evidence is still being received. And other times it may happen after the jury begins deliberations. And that distinction is important. When there is a juror who can no longer fulfill their obligations, then the next alternate up will just be shuffled into their spot. But what happens if the jury is sitting and deliberating after the evidence has been closed? Then an alternate can be substituted in that primary juror's place only if the parties agree. Now, in a criminal case, most defendants will say they're not going to agree, and then the trial will result in what's called a mistrial. In some instances, the lawyers will agree to substitute that alternate juror in the place of a primary juror and allow the case to reach a verdict. What does an anonymous jury mean? It depends on the gravity of the offense and who the defendant is. Now, in some instances, the jury is anonymous and the names are not revealed to the public, but they're known to the parties of the case. In other instances, because the defendant themselves, particularly in a criminal trial, usually with someone who is perceived to be a dangerous defendant, the jurors are anonymous in that they are not known to any of the lawyers or any of the parties, and that's to protect the jurors. Now, there are instances where you have a high-profile case, and every lawyer needs to be wary of that anxious juror. You have to ask yourself the question, why do they want to be on that jury, and how do they get there? Well, jurors are often motivated, in some very small instances, to become a juror because they want to write a book, because they want to be part of a movie or a TV show. They have their own financial advantages that they envision as a result of them being selected as a juror. It has nothing to do with fair and impartial. It has to do with their unjust enrichment. Now, how does the unsavory juror make their way on to a jury in an infamous case? Quite simply, they lie. When they're asked questions, they give answers that will put them in that zone where both lawyers on each side will say, I'm comfortable with that juror being part of this trial. I think that they can be fair and impartial. And they shield their true feelings. So lawyers need to be careful when selecting a jury that they are wary of those jurors who have an angle. And you need to ask specific questions to try and weed those jurors out. Typically, though, the jury experience is a positive one. Jurors get to be exposed to things that they wouldn't otherwise see in their everyday lives. And I think that they walk out of the jury duty experience saying it was rewarding. It was something that they would do again and recommend to others. So I guess I would say to you, if you walk into that jury room on that first day, go in with an open mind. Answer the questions honestly. And if you get picked, I think you might enjoy the experience.